Good morning, welcome to this full argument section of the full argument session of the Sixth District Court of Appeal. My name is Judge Jonathan Mize. My left is Judge Jonathan Pratt. My right is Judge John Starr. We are being live streamed, so everyone please keep that in mind. If you have not silenced your cell phones, please do that now. We have two cases on our docket today. The first case is 250921, Maureen Koch and Lucille Bishop versus Family Health et al. This is a law day, so we'll have a question and answer session afterwards. So lawyers, if you will, please stick around for a moment. And students, if you have any questions, you'll have a chance to ask them at the end of the lawyers for us. Counsel. We normally say 5 minutes for rebuttal. Is that okay?
Perfect, Chairman.
All right, please proceed.
May it please the court. My name is John Martino, and I have the privilege of representing the appellants, Ms. Maureen Koch and Ms. Lucille Bishop, in this appeal today. This appeal is not about whether or not punitive damages should ultimately be awarded in this case. It is about whether the trial court followed the procedure mandated by the legislature before punitive damages may even be pled under Section 768 of the Florida statutes. Pursuant to 768.72, the court is meant to determine whether a reasonable showing for a reasonable basis of recovery for punitive damages can be found by a reasonable jury. They are to do this by looking at the evidence in the light most favorable to the movement without any credibility or resolving factual disputes. The court failed in its duty in 3 significant ways, acting as a wall instead of a gatekeeper to the punitive damages. Number one, the court accepted a clear and convincing verdict that is reserved for the trial stage, not.
I saw you parsing the language of the trial court when it made its oral ruling. I also looked at the court's order.
Mhm.
The order it entered seems to track the burden it's supposed to apply. So I know you're saying that basically the trial court was trying to determine whether they approved it by clear and convincing, as opposed to whether there's sufficient evidence for a jury to find there's clear and convincing. And the trial court's order says there was insufficient evidentiary basis for the punitive damage claim to go to the jury. That seems to be saying there's insufficient evidence for each jury could find entitlement to punitive damages. So I get trying to parse or, individual pieces of language, but the ultimate order the trial court entered seems to have the right standard.
Admittedly, Your Honor, that order by the court, it's number one, it's very brief. It doesn't get into any details.
Got the right standard though, right?
Absolutely. The way it's written appears to be above reproach. However, if we look at what was actually said on that day, what the court was going into that hearing with and the understanding that the court had in approaching these issues was not the appropriate standard. So whatever the order may say, it's clear from reading what
The trial court made 2 findings, right? It's that I don't think you've proven by clear and convincing evidence, and that's not the correct finding. And the other finding is I don't think there's sufficient jury evidence for which a jury could find you to prove this by clear and convincing evidence. The fact that it made the correct finding and also not an incorrect finding, but just one that it didn't have to make, that would mean it gets overturned for not making the right finding. Right? As long as it applied the right standard, the fact that it made a comment that I don't think you could also meet some other standard, does that get you to a reversal?
We do. We think it does get us to a reversal here, because if we talk about this type of issue when it comes to whether or not punitive damages should actually be allowed, we are of course talking about the amendment stage, right? And we're not talking about the trial stage. The statute provides for 2 separate stages when it comes to this issue. The actions that the court undertook that day, and I'm talking about the day of the hearing, fundamentally changed the procedure. It changed what she was considering when she was deciding whether or not the case would be able to meet the burden that existed on that day, which is just a reasonable showing of a reasonable basis for recovery, not whether or not we proved our case by clear and convincing evidence, because that makes it a mini trial, which is not in all the case law.
Ultimately, the court made the right finding. The fact that there's this other finding, how would we rate that opinion? All right, the court made 2 findings. One of them was the right finding, one of them was superfluous. How do I write an opinion that says that the trial judge gives reversal?
Because that,
Would I be saying like, well, we can look at the trial judge's head, and even though he made the right finding, based on what was in his head, we think he didn't understand it?
well, the incorrect finding fundamentally affects the other. Without one, you don't, without the first one, you don't get to the second one. So, and if we look at what actually happened that day, the process was not undertook properly. We didn't get a shot to successfully get the punitive damages amended because the court disregarded important pieces of evidence that needed to be considered differently than they were. They were weighed against us when they.
Now you're getting into the issue, now you're getting into the problem.
Mhm. Okay.
If something, given everything, you have a response to my question about the standard, that's fine, we can move on. I'm worried about the standard right now.
Mhm.
I want you to tell me how I write an opinion where the trial court made the right finding, but it also made a finding that was superfluous and didn't have to make, but doesn't negate the other finding. Both those things could be true. It's not like they're consistent, right? How do I write an opinion that says trial court made the right finding, but we reverse?
If we, and I understand what you're saying, Your Honor, is it's hard when, as written, how are you going to say what was the court's intent, what was in the
Also, the
mind?
trial court can put part of its ruling in oral and part of it in writing.
Correct, and I agree with that, and I would say that the oral pronouncement here, the first thing the court said is that the burden to amend this is very high, it's clear and convincing. The court embraced the burden that was not appropriate at this stage of the case.
So counsel, but why shouldn't we presume, like even if the trial court erred there, that upon reflection and writing order, the trial court didn't go back to the relevant law and understand what the proper legal standard was? If we don't have on the face of this judgment an incorrect standard, why should we just presume it was the correct view of the law?
Because, again, this was a procedural issue that fundamentally altered the hearing that took place. It held us to a higher burden. It held the appellants to a higher burden to get to that punitive damage level.
But counsel, that's only true if the court didn't find the right standard, like just because it made a finding under one standard, which I'll take you as not the correct standard. That doesn't mean that its finding of the other standard can't independently stand alone. I mean, they're not inconsistent in some way. Like I don't understand what you're saying, like this fundamentally altered it. It's fundamentally altered, right? The trial court made one finding, it went on to make another finding. Those findings are in no way inconsistent. We need one of them to uphold. Like to say it fundamentally altered the nature, I'm just not seeing that.
Well, and just to be clear, it's beyond just the court stating that the burden is clear and convincing, right? If we look at the other recitation that the court made on the day of the hearing, there is weighing of evidence and resolving factual disputes.
All right, it's a different issue.
I know, I'm just saying with regard to that specific finding in the written order, I think there is more color to be provided by looking at the oral pronouncement
Right,
than
but
just
just
that.
return on the standard, I've got to do it based on the standard, right? In the answer brief, your opposing counsel pointed out, there's really no evidence of any kind of a managing agent or an officer, being involved in the false statements made by the regulator. I didn't see any response to that in your reply brief. I'm not seeing any evidence that there was any type of managing agent or an officer involved in their statements. What am I missing?
Well, first, what I would say is with regard to statements made by that agent, and I trust the court is aware of the relevant facts. In that situation, while we think that those statements are important to the negligent misrepresentation cause of action that we brought, ultimately, when it comes to punitive damages, we think that the volume of what happened here, the events from 2017 through 2022, that is events by the corporation that ultimately leads us to punitive damages, not that individual.
That seems to be a concession there. In fact, at least to the extent that punitive damages were sought based on those representations. It seems to be a concession that there, in fact, was no managing agent or officer involved, correct?
Not in the record, Your Honor.
Okay. Go ahead.
So as I was saying, Your Honor, as we look at the actual hearing and what happened that day, the court's obligation was to act as a gatekeeper. And it was to determine whether or not a reasonable basis existed that a reasonable jury could find punitive misconduct. As I was mentioning a little bit earlier, that was not what happened here. The court held the plaintiffs to a higher burden at an amendment stage than would typically be required. And is inconsistent with the sum of the case law that exists on this particular issue. Because the court embraced a clear and convincing burden and then weighed evidence and resolved factual disputes, we were not able to establish what we were able to establish if we just looked at the evidence. There was more than sufficient evidence here to establish that there was a reasonable showing of a reasonable basis for it.
I took your point in the brief about the proffer, and some of those items seem to have been, I'm not sure they were evidence in the record. I'm not sure the trial court relied on them, but I take your point that at least some of those items wouldn't appear to be evidence in the record. We looked at that, if we were to find that the trial court, utilized improper evidence, and we think he relied on it, we would do a de novo review on whether or not you met the standard. And when I look at the defendant has to have knowledge that there was a high probability that this plaintiff would be specific to the plaintiff. And it seems like in the context of a flood, that would mean you had to show the defendants had actual knowledge that there was a high probability that a flood would happen while the plaintiffs lived in this apartment.
Right.
Just being in a flood zone doesn't mean there's going to be a flood at any particular time or that any particular apartment's going to be flooded. Is there any evidence that they knew there was a high probability of a flood happening during this year of the lease and affecting this apartment? We're not going to even ever know that.
Right. Figuring out exactly when it's going to happen, absolutely. Your Honor, that's impossible.
All right, so then how do you meet the standard that they had to know there was a high probability that it would happen if you said nobody could ever know that?
Because the court may have read there were grant applications that the appellees filed to the government, basically asking for funds to undertake large mitigation projects.
They're trying to mitigate a problem. We're gonna punish them for that going
No,
forward?
absolutely not. That's not what we're seeking to punish them for. The relevance of those applications is that within them, they said the risk of reoccurrence was extremely high and will happen at any time.
No, so I'll take your point on that, but if you kind of assume that, they had to have knowledge that there was a high probability that this plaintiff would be injured. So
Right.
that would be that just establishing there's a high probability that a flood will occur at some point does not establish there's a high probability that a flood will occur during this lease term and affect this specific apartment, which would seem to be what you would need to show a high probability that this plaintiff would be injured.
With the exception of the fact that this particular apartment sat vacant for years because it was so badly damaged from 2017's Hurricane Irma.
Let me ask you this, but you have to know that there was a high probability that it was going to affect this plaintiff during their lease term, right? And there hadn't been a big flood like this for decades before that affected this apartment. How would they know, what evidence is there that they knew that there was going to be a flood while this plaintiff lived in the apartment?
This is not the traditional type of community where you think of it as a year-to-year lease. And certainly that's not how the appellants thought of it, or many of the seniors that moved into this community thought of that community. They thought about moving into this place as their forever home.
So they should have assumed that they were going outside the lease term and that they would be here however long it took for a flood to come.
This is a retirement community. They are marketing themselves as this is the place where you can grow old and live out the rest of your days.
Right, so, assume you have a 100-year floodplain. If we applied your standard to get to punitive damages, anytime there's 2 floods within a short period of time, so somebody knows, hey, you really are in that 100-year floodplain, and you recognize it and try to fix what you can still be punished for it.
But the issue isn't that they didn't problem. The issue is that they knew that this area of the residential community was prone to flooding, and they didn't do anything, not that they didn't do anything about it, but that they chose to renovate and move people in anyway without any kind of warning whatsoever.
Because sometime in the next 100 years, this could happen again.
Would that be the only though? If it was, forget the two name hurricane. Irma was the first one, or the second one.
Irma was 2017, and this is 2022.
So any apartment that is flooded by Hurricane Irma, obviously could be flooded by hurricane, we know. Like any apartment in the state, if it was flooded by Irma, we know that in theory it could be flooded. Does just every apartment owner then, forever and always, presuming they haven't spent tens of millions of dollars or whatever it takes to change the flood situation, is it just automatic punitive damage conduct? Anytime an apartment, the landlord rents an apartment to somebody without putting a flood warning sign on it? Because I'm not seeing why this apartment would be different from any of the other thousands of apartments that were flooded by Irma.
I think that this is, well, first of all, let me just say this is one of a bunch of related cases that we have filed against the FLEs. But this is a unique situation too, and I understand I'm going below the 5 minutes now, but it's important to really make this point. Since then, right, there's been changes in the law to require some flood disclosures on capital apartment complexes, in large part to situations like this that have happened across Florida, where people have lost everything.
That's fine, but for every one of the thousands of apartments that was flooded by Hurricane Irma, I don't see any, and then also flooded again by Ian, right? I'm not seeing any reason why this wouldn't apply to every single apartment in the state that fell into those two hurricanes.
And Captain, with fairness, I think your brief talks about a water treatment plant, rather than so maybe there is a slight factor distinction.
Yeah, it's not just the flooding. It's also that there was a failed sewage treatment plant on the property that contributed to massive amount of raw sewage into the flood that contributed to the losses that did take place. So you're right, Your Honor, that is certainly part of the back pattern here that we haven't addressed yet. My point in bringing up, though, that there's now the fact that there is a flood disclosure, first of all, with regard to Hurricane Irma, I don't think that there's any chance that there's going to be a bunch of lawsuits coming out, because I think we're past the statute of limitations for the most part for Hurricane Irma. And we're actually speeding up on Hurricane Ian as well, I believe.
But this could be repeated dozens of times into the future when there's 2 hurricanes.
Also, Ian is the relevant period, right? Ian is
Ian
when
is
the statute is when it's all occurred.
correct, but I think this is a very unique factual circumstance. And I would argue to the court that this is unlikely to be any kind of cause any kind of mass flood of new litigation, because number one, we are many years from Ian at this point. The idea that people would be filing suits at this point is probably pretty unlikely. And let me just say that people do not bring these suits typically. The reason why there's not a lot of case law that's anywhere near this here is because for legal aid stepping in and representing these people, no one would have taken these cases. We're talking about $20,000, $30,000 in damages to litigate for years. So if it's okay with the court, I'm going to reserve the rest of my time, and I'll talk to you guys in a minute.
In please support, I'm Bree Borland from the Organization Law Organization, we represent the athletes, Anthropologists American Society. As the court has recognized, the trial court applied the correct standard and correctly determined that the plaintiff did not present a reasonable basis of evidence to support an order of punitive damages. And as this court is well aware, punitive damages are the exception of the rule. There's an extraordinarily high bar for a certain claim for punitive damages, even more so when it's against a corporation, which is the case in this case. So there were really 3 categories of evidence that the plaintiff offered, and I think one of them has conceded today is not really.
Before we get to the plaintiff's proffer, can we ask about your client's proffer, the counter proffer? The thrust of your brief seems to be that the non-moving party can essentially put any evidence in the record by filing it. You basically say, we filed this, therefore it was on the record. Is something just in the court file, does that mean it's in the record and can be used as evidence of punitive damages on it?
So what we were saying is under the statute, just as the court can consider evidence proffered by the plaintiff or evidence in the record. So our position is we simply filed evidence in the record.
I know, but what does it mean, does anything you file become evidence on the record?
if it's competent evidence, I believe it's evidence in the record that the court can consider. I will say also, Your Honor, that you recognize that there's really nothing in the record that establishes that the trial court even considered our evidence that we put into the record. And, I think there were maybe.
Are you telling us we should assume the trial court wasn't supposed to consider your evidence?
I'm not saying that,
You need,
but I'm
you
saying.
need to defend the property.
No, I'm neither defending nor supporting the proper. I'm just saying that, yes, I believe
You're
that.
not defending your property?
No, I'm saying, first of all, it's proper. It was filing evidence into the record. I'm just saying that under the statute, we were permitted to do that. But in terms of reversal, what did the court consider? I'm saying we sort of view it as a non-issue because really the question before the court is what did the plaintiff present? And what the court found was what the plaintiff presented was not sufficient to satisfy the very high bar.
You get to evidence in the record, you get two pieces. You got evidence and you got it in the record. So I think evidence needs to be some type of competent evidence, right? Just a document unauthenticated, just because it's on a court file, that's how you get competent evidence.
Well, I don't think that there was ever any argument as to whether what we filed rose to the level of competent evidence or not. We would certainly submit that it does, but
I'm just asking you, if a document, permit application, whatever, unauthenticated, just filed in the court file, that evidence,
we believe it's evidence, yes.
why?
Again, Your Honor, I think if there's an argument in the trial court that your evidence that you've just filed is incompetent, then
But how is that authenticated in any manner? I get your point about what they argue, but I'm asking you about the substance of the issue. Does just any document without any authentication become evidence in the record that can be used by filing it?
So, Your Honor, I don't think that I can answer that question in a vacuum because I'm trying to stay within the confines of this case and in the record in this case. There was never an argument made before the trial court that anything that we filed wasn't competent evidence. The issue was, were we allowed to file it at all? So
On the flip side, was there any finding that was? So it should be.
I don't think it was challenged, Your Honor. I don't think.
And also, what they did was call it proper, and by calling it a proper, you could argue that means they're saying it's not evidence because it's a proper, which is by definition not evidence. So I'm not sure I agree with you that there was no argument that this wasn't competent evidence, because that's kind of what it means to call it proper. But proper is by definition not evidence. So I've asked you a few times about the substance, and you keep trying to avoid the substance of the issue. I want you to not do that.
Well, Your Honor, I guess I'm not trying to do that. I apologize. I'm trying to understand Your Honor's question. So.
Okay, so here's the question.
Mhm.
Evidence in the record. Okay? Assume they made all the proper arguments about whether you did submit it. Okay? A document that no one is authenticated, not attached to an affidavit, it's not an exhibit to a deposition. Is it proper for someone to file that and say it's evidence in the record? And if so, how? Given that it's not authenticated by anyone, and there's no proceeding in the case by which it was entered into any record.
Well, I think the way that it would work is the evidence would be filed as it was in this case, and then there would be a hearing on the evidence, and there would be discussions, and there would be challenges, and in this case, the plaintiff agreed that it was proper for the court to consider both sides of the hearing showings. The plaintiff also agreed that certain of those categories were acceptable and permissible.
Hold on, the plaintiff agreed that it was proper to consider evidence in the record, but said that some of your items were proper rather than evidence. That's what they argued. They said this was an improper proffer, right? That means it's not evidence. And so some of these items didn't go through that process. There was nothing in the case where they were admitted as evidence or need to be competent evidence, right? They weren't attached to a deposition. They weren't attached to an affidavit. So as to those items, how do they get to be competent evidence with no authentication? And what would it mean for them to be in the record? If that's not it, unless you're saying it's just synonymous within the court file.
Well, we took the position, according to the law, that a proffer is a representation of what evidence will show. So the plaintiff makes the proffer, as the plaintiff did in this case, attach all kinds of things and that the evidence will show this. That was a proffer.
And they get to do that. You don't get that, right? You said,
We filed, so if we can look at what it is we filed, depositions. Two of the depositions, the plaintiff had no objection to. We filed an affidavit. We filed some building permits.
well, that's a different, so a building permit. How
So,
does a building permit get to become evidence without any authentication?
Your Honor, again, I don't think this was challenged in the trial court.
I'm telling you, I think it was, so I want you to answer my question.
Okay, well then, Your Honor, then for the sake of argument, I don't believe that it was, I don't believe that the evidence was not competent. But for the sake of this argument, I would say it's hard, it would be harmless error.
What makes it competent?
I don't know what makes it competent. It makes it competent that it was never litigated, that it wasn't competent. It was evidence.
What makes it evidence?
Well, I think the plaintiff has relied on the same types of evidence. These are, in fact.
They get to proffer.
Well, but they actually relied on the actual applications that we filed with the government entities. That was the bulk of this evidence, was the applications we filed with government entities saying, we're trying to mitigate this problem. This is what it's going to cost. We're advocating for funding. We're trying to remediate the property. These were the types of items of evidence that we filed. No one challenged them as incompetent evidence or unauthenticated.
Counsel, remind us by what method was were these exhibits filed, or you were attempting to put them in evidence?
I wasn't the one who filed them, but I think they were filed with a notice of filing.
Right, so this is not like a summary judgment motion where you attach affidavits, depositions, you're seeking to put them in the record. Someone then responds, has a chance to forth their contrary affidavits, depositions. That seems to be kind of in the world of, maybe you don't need the judge to authenticate because the parties are right there disputing it. But here's just a motion to have the judge consider something kind of it's not improper, it's just I'm having trouble seeing how that's getting into the record.
So, Your Honor, again, the case law is that on punitive damages, proposed amendment, the courts can consider both sides of engineering killings. The notice of filing was made, attaching all of this material.
That isn't the question. We get it. The court can consider evidence on the record. Nobody is disputing that. The question that we're asking you to answer is, how did this become evidence in the record? And your answer seems to be, well, we filed it. That would mean that just anything anybody puts in the court file is evidence in the record. And I'm questioning whether that's correct, because evidence would seem to me to require some type of competence. And in the record, to me, would seem to require something that put it in the record of this case, as opposed to just the court file.
So I guess, Your Honor, I don't know how else to answer this question other than a notice of filing was made, as it would be on summary judgment. If the parties want to challenge those filings, then it is up to the opposing party to say that the evidence is incompetent. It's up to the court then to conduct a hearing and determine whether this is competent evidence.
Counsel, what do you call it?
A notice of filing is not a motion. You're not actually seeking to do anything. You're just apprising the court that something exists, correct? People
So,
make notices of filing all the time of things that are irrelevant, extraneous, never considered, but the court's not being asked to do anything.
right. So, Your Honor, I've answered it the best way I can, and I guess what I'm struggling with, I'm not trying to avoid the question. I'm not trying to be difficult. I'm just trying to say that I'm here to argue that the trial court should be affirmed for correctly denying the punitive damages amendment because the plaintiff is the one who had the burden of making a showing, an evidentiary showing supporting a punitive damages amendment. So I'm not going to say one way or the other whether our filing was or was not competent evidence. I would say this court can decide this particular case without what we filed. As Jeff Weinstein recognized, there's nothing in the record to suggest that the trial court even considered the defendant's filing. So I could concede, well, let's pretend that it wasn't competent evidence and let's just put it aside. Let's put aside the defendant's filing. I'm going to concede that for the sake of argument, because what I would like to tell the court is what I think the court has already acknowledged, that the plaintiff's evidence fell into three categories, and one has been conceded today is not in that category anymore, and that was the CAS limited statements that I don't think the property will flood again, and the things that they say instead. He says he didn't say it, but viewing the evidence in light was favorable to the plaintiff, assuming he said those things, as the court has recognized, there was no managing agent from the corporate entities that participated in that. So the CAS limited statements are off the book. I mean, they don't support the punitive damages amendment. There was another category that we didn't get into today, but one of the third category was we were somehow duped into signing this termination agreement. I don't know if it's proper for me to comment on that because it didn't come up in the opening argument, but the plaintiff's own testimony refutes that. They said they voluntarily signed this agreement. So it really comes down to this notion that somehow we had we failed to reasonably maintain the property in a way that would prevent it from flooding in this, 1 in 200 year catastrophic storm. And I think the court has also recognized that, are we to be penalized for all of the efforts we took to mitigate the property? What could we have done? How could we have predicted the storm? How could we have predicted what it would do to these particular plaintiffs? It's just, this category is the sort of the standalone category left, I suppose, and it doesn't come anywhere near to satisfying the very heavy burden under the punitive damages statute. I mean,
And counsel, could you maybe speak briefly about, I guess maybe what would be considered potential omissions your client made in its applications for, basically getting assistance for remediating or fixing the property up? Whether and how you look at this in light of the intentions of gross negligence standards.
right, so, in advocating for funding, obviously our client, acknowledged the potential for harm from flooding and had flooded before. And think about it, this was certainly to protect the residents, but it was to protect our client's own property. So they had every incentive to make sure that this property was safe, that it was safe from flooding, to the extent it could possibly be safe from flooding. And so in those applications, that's what they were trying to do. I mean, this was gonna cost in the millions and millions, hundreds of millions of dollars, but it was gonna be an exorbitant cost. They advocated, they told the government entities that, we're concerned about this. The government entities did not find it a high enough priority, funding didn't come through. So I think the plaintiff is even admitted to even come anywhere close to mitigating against these effects, which again, I don't think you could do in a storm size community. That it would make cost prohibitive. And Your Honor, Judge Pratt, excuse me, you mentioned the wastewater plant. That is something that we were able to start working on. And unfortunately, we didn't come through the old engineering phase of correcting some of the problems with the wastewater plant. So in terms of, did we maintain the property in a reasonably safe condition? I would just say, what more could we have done than we tried to do? And even in that case, and beyond that, in the statute, it wouldn't be intentional misconduct, because I don't think anybody could claim that we intentionally exposed our own property in a way that would destroy it and also would cause the residents to lose their belongings. I think it could only, I suppose, come under gross negligence. And it would be the defendant's conduct was so reckless or wanting and care that it constituted a conscious disregard or indifference to the life safety rights of persons exposed. Well, what conduct are we talking about? Our failure to undertake these multi-million
I think we're
dollar.
talking about your failure to warn, or the alleged failure to warn. Hey, you should have told us.
Well, no, I don't think so, because at the trial court level, the judge asked the plaintiffs, what is there a duty to warn of potential hurricane or flooding? And they conceded that no, there's no duty to warn, there's only a duty to maintain the property.
I think what they said was that no court has yet recognized the duty to warn. I
Right.
can't find the case. I don't think they said there wasn't one. They said that there's no court case saying there's a duty to warn for flooding.
Well, and I think that comes back to the Cass Plumbing statements. I mean, our clients had, the corporate entities had these employees that met with the different residents, and one employee supposedly said that it wasn't a big deal. But again, this isn't a situation where a managing agent was involved in any of this. So based on the record, I think this comes down to the failure to maintain. I think the duty to warn was sort of, it seemed to me it was a bit conceded, but I don't know what conduct would rise to the level of criminal manslaughter that our client would have engaged in, intentionally, exposing people's, life and safety. I mean,
Counsel, are you aware of any Florida health court decisions or Florida Supreme Court decisions with any analogous set of facts or where there has been some finding of intentional misconduct with gross negligence or failure to maintain a property like this?
Your Honor, I've not seen one, and I have looked. I have done a lot of research trying to find anything, not only in Florida, but around the country, because it just seems like such a, it would be very dangerous precedent to expose a property owner to liability, much less punitive damages, for failing to be able to predict a storm of the size, the magnitude of the size of Ian, the flooding that occurred, and this was a devastating storm. This is Pamela's, where we all went through it. And it just, again, these facts just don't fit within the four corners of the punitive damages statute. They don't fit within the four corners of Florida law. Again, this court knows, or Supreme Court has said gross negligence has to be akin to criminal manslaughter. This court in Mercer and recently in the Turo decision talked about the egregious level of the conduct. This was a very unfortunate event. It was unfortunate for the plaintiffs. It was unfortunate for our clients, but there was no criminal negligence involved here. And I would just mention this court's recent ruling in Turo gave example of cases where people died and there was knowledge of the problem that led to these deaths. And this court said even that doesn't rise to the level of punitive damages. So I would say we are well below what this court talked about in Turo. And again, we don't believe that the plaintiff fails to satisfy the burden of the statute. That's what the trial court said. We'll respectfully requesting the court affirmed. Unless the court has any further questions, I'll leave.
To briefly just address the Turo decision, the facts here have nothing analogous with that decision whatsoever. In that case, it was a third-party platform, and there were individual owners of cars that were renting them out to individuals. Here, we're talking about the actions of the appellees that, in some cases, inactions regarding a failure to warn. It's correct.
Similar in Turo, and that they were trying to hold them to a standard where they had to warn people that there was a light on the dashboard and that can happen to something additional that could cause danger.
The difference here, Your Honor, is that in this particular situation, we know that the direct appellees knew of the risk because of the grant applications. They knew that it was at risk of imminent reoccurrence of flooding at any time. So this is a completely separate issue because in Turo, the notice issue was the issue, whether or not there was notice. But in this situation, we know there was notice.
So as you said, the remedy here was for the landlord to just leave the property vacant until whatever point in the future they felt there wasn't going to be another storm that could damage this property.
That could have been an option until they.
Economic waste. It's ruining. You built this on a 100-year floodplain. We're sorry that you did that. And now as a society, we've got to stop building it on a 100-year floodplain or you could be subject to punitive damages.
Or they could have paid for the mitigation efforts themselves. We're talking about billions of dollars in this corporation. They could have made that decision. Just because they didn't get the grants that they wanted to doesn't mean that they still don't have a duty to either fix the property or warn the individuals. And even though there was not a statutory requirement to warn at the time of 2022, under just general negligence law, if there is a problem with your property, you have to warn people. And they didn't do that.
What about their efforts on the wastewater plant?
That was similarly, they applied for a grant, they got some money for that and were starting to undertake that. But ultimately, it didn't happen within the 5 years in between the storms. And ultimately, this flooding would have happened one way or the other. And I will just say real quick, there's plenty of examples in the reply brief. The error here was invited by opposing counsel, and it fundamentally changed things. Thank you for your time, Your Honors.